Every single day we're online. We click, we share, we post, we create. But have you ever really stopped to think about the invisible rules that are running the show behind the scenes? Well, from the photos you post to the articles you read, there's this whole set of rights and responsibilities at play. And today, we're going to pull back that curtain and make sense of it all. So here's what we've got on deck. We're going to start with the data that basically defines you online. Then we'll talk about how to protect it. After that, we'll jump into the really interesting world of creative rights. And finally, we'll tie it all together to figure out what it actually means to be a good, responsible digital citizen.
Okay, so let's start with the basics. We hear this term personal data thrown around all the time, but what is it really? This stuff is the absolute foundation of your digital identity.
So take a second and think about it. What information about you is so uniquely, you, that the law considers it personal data? I bet it's a lot more than you think. To put it simply, it's any little piece of information that can be used to identify you. Yeah, the obvious ones are your name, your photo, your email, but it goes way deeper than that, to things like biometric data, your fingerprints, your iris scans. It's like a digital breadcrumb trail, and every single crumb leads right back to you. Now here's where things get really important. The law makes this huge distinction between your basic data, like your name or address, and what's called sensitive personal data. This is the heavy stuff. Your race, your political views, your health status. This info gets way more legal protection, because if this stuff that's out, it's not just about privacy, it could lead to real-world discrimination. It's a big deal. And because this data is so valuable and so sensitive, there are some really strict rules in place to protect it. And let me be clear, these aren't just suggestions. This is the law. This brings us to what I like to call the golden rule of data protection. It is the single most important principle. A company can't just take your data. They need your clear, explicit permission first. Your consent is literally the key that unlocks your data, and you're the one holding it. Now, of course, there are a few very specific exceptions. We're talking about things like a legal requirement, national security, or literally saving someone's life. But the key thing to remember is that these are rare, serious situations. They are absolutely not loopholes for businesses to use every day. So how do companies get that consent from you? Well, it usually comes down to two systems. Opt-in is where you have to actively check a box or click I agree before they can touch your data. Opt-out is the tricky one. They just assume they have your permission and they keep collecting your data until you hunt down the setting and tell them to stop. Knowing the difference is huge for understanding what you're really agreeing to online. All right, so we've covered the data that makes you, you. But what about all the things we create? The photos, the articles, the music, the ideas we put out into the world? That's where something called intellectual property rights come into play. At its core, intellectual property, or IP, is all about protecting the things that come from our own creativity. It basically makes sure that if you invent a new gadget, or write a song, or design a logo, you have legal rights over that creation. It's yours. But IP isn't just one thing. Under the umbrella of industrial property, you have different tools for different jobs. A patent? That protects a brand new invention for 20 years. An industrial design protects the unique look of a product, its shape, its color, and a trademark protects a brand's logo or name. Think of these as legal shields for business and innovation. So, on the other side of the IP coin, you have copyright, and this is where it gets really cool for creators. While industrial property is for commercial things and requires a bunch of paperwork, copyright is for artistic works, books, music, photos, and here's the magic part. The protection is automatic. The second you create it, it's protected. You don't have to do a thing. So how long does that automatic protection last? Well, it covers your entire lifetime, plus another 50 years after you pass away. That's a long time. And it's designed to make sure that both you and your family can benefit from your creative work. But listen, these rules aren't just about locking content up and throwing away the key. The whole system is actually designed to allow for the fair use of information so that culture and knowledge can keep growing. You see, at its heart, copyright law is this delicate balancing act. On one side, you have to protect creators so they're encouraged to make new things. But on the other side, society has to be able to comment on, critique, and build upon those ideas. Without that, culture just stops. So, how can you use someone else's work fairly? Think of it like this.
Your creation has to be the main event, and the quote is just a supporting character. You have to always give credit where it's due. And for goodness sake, don't change what they said. Stick to these rules, and you're generally in the clear. Now, to make all this sharing even easier, we have something brilliant called Creative Commons. It's a system where creators can basically give everyone permission to use their work ahead of time, as long as they follow a few simple rules. It's like saying, hey, yes, you can use this, just do it my way. The foundation of all Creative Commons licenses is attribution, or BY. It's super simple. You can use the work for pretty much anything you want, as long as you give credit to the person who originally made it. That's it. Easy, right?
Next up is NC, which stands for non-commercial. This means you can use it, you can share it, but you just can't make money off of it. It's for creators who are happy to share their work for art or education, but don't want someone else to profit from it.
Then you've got ND for no derivatives. This one means you can share the work, but you have to share it exactly as it is. No remixes, no edits, no changes at all. It's a look, but don't touch kind of license. And finally, there's SA, or share alike. This one is really powerful. It says you can change the work, you can build on it and make something new, but if you do, you have to release your new creation under the exact same share alike license. It kind of keeps the creative sharing spirit going.
So, we've walked through personal data, consent, copyright, fair use. When you put all of these pieces of the puzzle together, they form a kind of guide on how to act online, how to be a responsible, thoughtful digital citizen. And that, right there, is the most important part. This isn't just a bunch of abstract rules. This stuff actively shapes how you browse, how you share, and how you create every single day. So the real question to ask yourself is this: now that you know your rights and the rights of others, what are you going to do differently?